All right, Kevin, here we are in the readathon.
It is a readathon.
And we are recording it remotely. Mm-hmm. Where are we, Kevin?
We are at our beach rental.
Yes.
So we are giving up part of our summer vacation.
That's right. And we are actually in the great Commonwealth of Massachusetts. We are.
And it looks like a much sunnier day in Norfolk County than it does here on the North Shore.
How do we know that?
Well, we're watching a little bit of court TV so that we can do our own analysis and reporting of the Karen Read hearing. So this part of the readathon we are recording before
That's right.
the hearing.
We're about to watch it.
Yeah, so it's going to be up in about 20 minutes.
Mm-hmm. We have been watching court TV talking about this hearing, which is coming up. Mm-hmm. And I'm curious, one of the things that we've watched on court TV, are the anchors and then their own legal analyst who's been coming on and talking about his takes on the case. Mm-hmm. We are so embroiled in our takes on the case and, our own analysis of our observations of the trial unfiltered through the court TV takes. Mm-hmm. I've been really surprised to sort of hear this alternative analysis of the evidence of the case. What have you thought as you've watched this dude talk about Karen Read being a charlatan who's fooled her very competent attorneys into waging this defense and so forth?
Well, it's not a unique or unheard of take on the case. There are a lot of people that, can see the evidence differently. It can focus on different things and draw different conclusions. One of the parts of the case that is probably harder for people to get into is the idea of an actual police conspiracy. Mm-hmm. That police officers would manipulate evidence and do certain things. And whereas one might say, yeah, 100% they did that, or say, yeah, this is a combination of incompetence combined with maybe doing one thing that led to two things, that led to three things, but not we need to do three things, right? Or it's, that's a part of it, as opposed to maybe looking at, the physical evidence and how it indicates that these injuries were not caused by a car accident, that there's a lot of evidence to say that he went inside, and there's, if you don't look at the Albert side of this incident, and you just look at Karen Read drove her car, she was obviously incredibly drunk at the time.
Yep.
And to some people, she does not come across as likable.
I know.
It is,
even though we've barely heard anything from her except to look at her in trial, being with her parents.
Right. I don't find it unusual for, and especially an attorney who is looking probably more coldly at facts and evidence and how that plays out versus maybe some of the other things that people use to draw their conclusions.
You know what I've been thinking about a lot, especially watching this guy who's obviously coming from a very prosecutorial perspective. Mm-hmm. Imagine if the case were different. So imagine if the police had arrested somebody from inside the Albert residence. They had arrested either Brian or Colin mm-hmm. or Brian Higgins, say. And the crime being accused was assault, leading to his death, John O'Keefe's death. So, say manslaughter. There was a fight in the house, manslaughter or murder too.
Yeah.
That they had killed him. Injuries were done in the house that had led to his death by dragging him out and dying in the snow. And their defense was, no, Karen Read actually hit him with her car. And we're going to prove it because, look, her taillight is cracked. Mm-hmm. And look, the police actually mm-hmm. covered this up by not properly investigating this hit and run. And we're going to bring in all these experts that show how this death could have happened by car. Mm-hmm. And their evidence was what we saw Trooper Paul do. This thing with this crazy thing with spinning around and, that would have been their defense.
Yeah.
Do you think this prosecutorial point of view would be, wow, Brian Albert / Colin / Brian Higgins is trying to wage this crazy conspiracy. Look at this nut trying to come up with this wacky conspiracy. They were drunk inside the house. They were really, really drunk. What are they trying to do? Fooling us that this actually happened outside and clearly his injuries don't match being hit by a car. And they're trying to fool us and say they are?
Yeah, I mean, I could certainly see.
You know what I mean?
Yeah, I don't think that would be their defense's go-to immediately. But if something happens down the road and somebody from the Albert after our party, is charged in connection with the death of John O'Keefe, then that is exactly what they are going to do at trial, is they are going to say, well, the Commonwealth accused somebody else of this crime, and the Commonwealth presented this kind of expert testimony and this and that and the other thing.
Right.
So, I mean, that's sort of the problem of having target lock on a defendant when you realize later that there are issues with the case.
Right. I mean, that's not exactly what I'm saying. I get what you're saying. What I'm saying is, I could imagine the same people. Do you think
that expert would come back and say the same thing?
I'm saying the same people who are saying that, like, it's wacky that there'd be a, quote, conspiracy, quote, cover-up on this side would be saying the same thing if it were the other way around. It would be saying exactly the same thing. As if it's so unlikely, as if it's so unusual, as if it's so... But the bottom line is, his injuries do not match being hit by a car, period. They just don't. And whatever you think are the combinations of what could have happened, that is the one fact that everybody should be paying attention to.
Yeah. The black eyes, the gash in the back of his head, what very much appear to be dog bites on the hand.
And no injuries below the neck.
Yeah, no bruising, nothing below the neck that indicates being struck by a vehicle.
Not to mention that her car in no way indicates that it hit a person. The theory of the accident makes no sense. His body is not where it would be if he were not hit by a car. And the data on John O'Keefe's phone indicates that he went into the house. And she was not there when the data on his phone shows him stopping moving. She was no longer there, according to the prosecution.
By the way, I'll say that I backed up the car in reverse today, and it went 5 miles an hour, and it felt like I was in a toboggan backwards.
Right.
So to say like she got up to 27 miles an hour in reverse.
24, ridiculous.
24. I mean, to press the pedal 70%. I guess you'd have to press it that far to...
You'd peel out. It would be ridiculous. Yeah. All right. So one other thing I wanted to mention before we watch the trial. Earlier this week, it came out a couple days ago while we were here, but I wanted to mention in this recording that the Commonwealth of Massachusetts has sent a so-called Brady letter to more than a dozen defense attorneys with active cases in the state of Massachusetts about Trooper Michael Proctor. Do you know what a Brady letter is essentially?
Well, I guess it's in compliance with Brady versus Maryland, where the prosecution is disclosing exculpatory evidence for defendants.
That's right.
And they would probably very easily argue that the fact that they have an unreliable witness, or they have a witness who, or you have an investigator who has been put on leave and is subject to an internal investigation, that would tend to be exculpatory evidence for the defense.
That's right. This is what the letter to the attorney says. Dear attorney, this letter is to inform you that, pursuant to Mass Criminal, the code, the Norfolk County District Attorney's Office is aware of information that in Commonwealth versus Karen Reed, Massachusetts State Police Trooper Michael Proctor testified and was subject to cross-examination relating to alleged conflicts of interest, communications with non-involved civilian persons regarding the case, and statements regarding the defendant from which defense counsel argued a bias could be found. In addition, this office is aware that Trooper Proctor is currently suspended without pay pending an open internal affairs investigation by the Massachusetts State Police. And then it goes on to say that there is an unofficial transcript attached and that a better transcript will be attached. And it says, to the extent that this testimony references a prior proceeding and text messages, such material is subject to a judicially signed federal court order and not within control of the Commonwealth, et cetera, et cetera. So basically, this is a letter sent to more than a dozen defense attorneys, and there's talk about all the other cases that Proctor could be touching, not just open cases.
Like perhaps that cold case that he and was it Brian Albert?
Yes.
Returned from and got so drunk that one of them lost their service weapon.
There are many cases that he's both directly and indirectly involved with. Sandra Birchmore case. There's an officer-involved shooting case. And there are some other very high-profile ones. Needless to say, these lawyers are going to have their hands full, and cases involving Proctor are going to get a lot of looks.
Right.
All right. We are a few minutes out from this hearing starting, so should we pause and come back after the hearing's over?
Yes.
All right. Let's do that. All right, Kevin. So we just watched it.
Is there like a special sound effect we can do to indicate that we just we stopped and came back?
Like the harp or something?
Yeah, we don't have a lot at the beach house. So,
That's true. That's true. I don't have a lot of equipment or access to my hard drive here, but I'll see what I can find on my laptop.
All right.
So we just watched attorney Martin Weinberg for Karen Reed argue his motion to dismiss the case based on what he says is factual evidence that, and this was a huge part of his argument, that the jury was unanimous on not guilty on two of the charges against Karen Reed. Of course, the second-degree murder charge and the lesser charge, which was the leaving the scene of a death. So what do you think of this argument that, he just put out there? This is essentially what he said, and he wrapped it up again in his rebuttal at the end. We have factual evidence were these 5 jurors that approached both the defense and the Commonwealth, that there was unanimity, that it is central to our criminal justice system to explore that. And all he's asking for to this judge, which he says he trusts, who he trusts very much. He's very respectful the entire time.
Right.
Never implied she made an error of any kind.
Right. Good move.
That he trusts her very, very much. And all he's asking is something that she does every single day, which is to voir dire, go through the process of voir dire with these jurors and just ask them the question. That's all he's asking for.
Yeah, I mean, a couple of interesting things. I think you're right that he was very kind and deferential as to not antagonize the judge, which is, I think, always good when you're making that argument.
Yeah.
I think that if the judge rules against Karen Reed, then when they will appeal, and the tone of those arguments will be different.
Yes.
I think it'll a lot of it will. I mean, it's almost always judicial error is the basis for an appeal, and so they're going to say that Judge Bev effed up by not asking, gets more specificity from the jury when they said that they were deadlocked. So it seems like one of the things either that they were anticipating the Commonwealth to say, and they were trying to preempt this, was that the Commonwealth was going to say, the rules prohibit us from talking to the jury.
About process in the jury room. Yes, deliberative process.
Right. It prohibits us, which is why we couldn't and why we can't now.
Yeah.
Which is why we can't go back. They're citing a lot of case law, as one would here, trying to come up with certain cases. I did enjoy that there was one case which was called Commonwealth versus Juvenile.
That Lally brought up. And then, is it Weinberger? Yeah, Martin Weinberg.
Weinberg got up and not only wanted to point out why that case was not on point, but corrected that he got the name wrong. That it's Juvenile versus Commonwealth.
Yes, and
so he's very. I mean,
very prepared.
Very prepared. And why haven't you heard of Martin Weinberg during the criminal trial? It's because he's a new addition to the team. He's primarily an appellate attorney, and he is a big swinging dick in the Commonwealth. He even flexed a little bit as he's talking. To mention that he knew he knew the guy who the courthouse was named after, So again, he's just trying to flex a little bit here, and he draws a lot of water when he's speaking.
Bev was listening to him in a way that I will say I've watched Bev Canoni for this whole trial. There was a lot of respect emanating from the bench as Martin Weinberg talked. He was extremely prepared. When Juvenile versus the Commonwealth came up, or as Lally called it, the Commonwealth versus Juvenile, one thing that he pointed out, which has happened before in this case, was that Lally stopped reading the case law before the part that would have applied to the defense.
There just seemed to be a couple where Lally does the same thing again, where he kind of loses his place. And there's a pause where he has to ask the judge for the indulgence of a
long ass pause
so that he can find his place. And then you see him moving his papers on his legal pad and flipping up and down, trying to either find his space or figure out where he's going to jump to because he needs to skip a bunch of stuff. So the fine lines, the really straight lines, aren't always there with the Commonwealth. But this is what they're arguing, basically saying, hey, can't do it.
Right.
They're not arguing that the jurors would come back with something else. I think that the defense is asking for is if the judge is unsure that was the result in the jury room, to just go ahead and
ask.
bring them back in. The state, the Commonwealth was saying, well, that would be deleterious to the jurors, that they're afraid of the media and all this other stuff, but, the intimidation of coming back in.
But also that they would have been influenced by media they had seen after the trial to maybe have changed their mind about what they believed to be true. And that's when Weinberg said, Judge, no. You do voir dire. I trust you. I trust that you'll ask them properly.
Yeah.
What did you think on that day? And I trust that you'll get a true answer. Such a good way to phrase it.
Plus, it's also a very simple question. They're not trying to probe like, were you inclined to believe?
Yeah.
Or what was your perception of? They're basically going to ask, you're just going to verify, were you not guilty on this charge? Were you deadlocked on this charge? They don't even have to ask which way were you leaning.
Right.
Do you know that what was the count? And if anyone's not going to say, 4-3 or whatever. And certainly they were telling the court basically everything that had been written down in all the affidavits. And there was, certainly Lally said one thing that was kind of interesting, and I didn't know if it was a slip or anything like that. He was definitely trying to defend why the Commonwealth did not act when the juror reached out.
Yep.
And he said he tried to explain why they didn't act when jurors reached out.
Yes.
So again, I don't know if that means much. I'm just trying to think whether or not I'm trying to think back to all the paperwork filed by the Commonwealth, whether they indicated they were
approached by
more than one juror.
Well, they have evidence they were approached by one because that person left a message.
Yes.
So a couple things. One of the things I want to mention is that the two cases that Lally cited, the juvenile case, that was a Massachusetts case.
Right.
That case didn't apply, as Weinberg pointed out, because Lally didn't read this part. That case didn't apply because the charges weren't concurrent. The charges weren't separate charges. Mm-hmm. They were like a string of charges, one charge with lesser charges below them. Mm-hmm. So it was a different kind of case.
Right.
And the other case was an Alabama case.
Right. And I'll say that the reason, the thought process behind that one is that it would require the jury to then decide, oh, well, is this like really second degree or I don't know specifics of the case, but to, again, find some variance within what those charges were as opposed to a thumbs up,
you
thumbs down.
have to be deadlocked on the top charge. Being deadlocked on a lesser charge does not count, basically.
Right.
Which makes sense if you think about it, because if the lesser charge is a component of the top charge, the top charge is the one that matters in those kinds of cases.
And there are cases where someone could be charged with first-degree murder and second-degree murder at the same time based on alternative theories of the prosecution's case.
Right.
As opposed to, if you can't get on, first degree, you can get on second degree.
Well, that's what happened in this case.
In this case, though, the three charges were different charges.
All separate.
Right? The vehicular manslaughter is not in lieu of second-degree murder.
It's a separate charge.
It's that she committed second-degree murder, and she committed vehicular homicide, and she left the scene of an accident.
Yes.
Right?
Which is interesting.
Yeah. So it's not like you can also find on this one and not that one. Anyway, but so that's what the juvenile... And juvenile certainly not someone's name. It's their way of saying John Doe.
Right, it's not juvenile, the artist.
Yes, yeah.
And the other case was an Alabama case where the jury came back, multiple charges. They came back, they said they were unanimous on one, but deadlocked on the others.
Right.
Judge sent them back out, and when they came back, they were deadlocked on all. And so the person appealed saying, I shouldn't be retried on this one because the jury had said at one point that they were unanimous on that one, but then the court, I guess, sided with the prosecution on that one too. So he cited that one. And again, Weinberg is like, this is different. A jury never came back in and said unanimous. They were just never asked about anything. Yeah. So like,
and a case from a different state. Like, it's not a federal case. Different state. So it's more of an advisory thing. If this was on point this was a case from Massachusetts, it probably would have a little more weight. But this is an advisory thing where you say, Judge, this is what they did in this state in this particular case, and so that's some sound legal reasoning that you should apply.
Right.
They seem to be armed with that particular case.
Right. Well, he was obviously prepared for the state to cite it because he had a piece of paper which had both of those cases on it. So speaking of out-of-state cases, speaking of other cases, the central part of the defense's argument here came from some Supreme Court decisions and some high-profile case decisions, which was about jury misconduct and how you would remedy that. So it was basically like, if you found after a trial, and he named some high-profile cases.
Boston bomber case.
Yes.
Which was also a Massachusetts case.
Yes.
Yeah.
If you found after a high-profile
case,
trial that a juror had been improperly influenced during deliberations, or a juror had been influenced by racial discrimination during deliberations, that you could then voir dire the jury. And you can, dismiss the charges, determine, retry, or that person would be subject to double jeopardy. So there's a whole case law thing there. And he said, essentially, this is the same, except even though it's flipped, even though the juror is saying that they found her not guilty, there is precedent to voir dire a jury after a trial is over. If you can ask juries questions for these reasons, can't you also ask juries questions for this reason? It's not about deliberation. It's about what they decided. So I thought that was a very interesting point. And he basically was just saying, this is central to our criminal justice system. It was a very clean argument. It's a stretch, but it's clean. What did you think about that?
Yeah, I mean, I think it's very well researched. I think, what ends up happening is that the judge generally goes back when they cite a case. A good judge will then do his or her own research and then go to the law book and look at the case and see for themselves, right? It's kind of like if you've got a footnote in a history paper, then the teacher going and finding the footnote, going into that book and checking out where that came from.
Right.
So if it's misrepresented in court, the judge has the ability to get their own determination from it. So what's going to happen now is Judge Bev. Can I call her Judge Bev? Is that like...
Judge Cannoni.
Judge Cannoni.
With the excellent bangs.
Okay, with the excellent bangs. So Judge Cannoni took it under advisement, left the bench.
Yep.
So it means that she will have a written decision which will be published at some time in the future.
That's right.
And she will, spell out all her reasoning for, and that'll be the basis for what undoubtedly will be an appeal by either side, by the losing side in that decision. Yeah,
my gut tells me the defense will lose this because it's never, it would be a precedent if they won, which would be amazing. But my gut tells me they won't win it and will appeal it, but who knows? But that doesn't mean Weinberg, by the way, fantastic attorney. But also that courtroom, not well mic'd today, so it was very difficult to hear.
I think it depends on which feed you're...
I'd recommend...
Who's got the house feed and who's just trying to use the the shotgun microphone. And
I'd recommend to folks they do not watch a replay on either one of the television stations that's broadcasting this. Just go straight to the NBC 10 Boston YouTube feed. It has the clearest audio.
Skip Court TV.
Best visual. Skip Court TV. Their analysts suck.
Law and crime.
And Law and Crime. Just the audio isn't great. Anyway, so Kevin, I guess we're going to get a response from Judge Cannoni at some point with her fabulous bangs, and we will be back, of course, when that happens. And we're very likely to be back before then because there's other stuff to talk about, and we've been on vacation and haven't been able to talk about it. So
absolutely.
All right, that's it for this edition of the Readathon, and we'll talk to you soon.
Partners in Crime Media.